Andrew Rosenberg law. Clear plans, peace of mind. Andrew Rosenberg law. Plan it right, protect it all. Andrew Rosenberg law. Guiding you when life gets hard. Andrew Rosenberg law. Peace of mind, secure your future. Andrew Rosenberg law. If you don't plan, you're stupid.
Welcome back to If You Don't Plan, You're Stupid, with Florida estate planning attorney Andrew Rosenberg. Andy helps South Florida families protect their legacy, avoid legal chaos, and build plans that hold up when life gets messy. I'm Leann Lyon, and today we are breaking down the difference between revocable and irrevocable trusts. Andy will explain what they are, how they work, and why choosing the right one matters in Florida. Hi, Andy. Great to see you again.
Hey, Leann, how are you? Good to see you.
Great intro, by the way. Love the music. So fun.
Thank you. Thank you.
So, Andy, what is the core difference between a revocable trust and an irrevocable trust?
All right, the big difference, a big difference. First off, when I do my workshops, everyone's always asking me, we need trust. And then they always hear what, revocable, irrevocable, which one do I need? And I tell people now it's changed a lot over the years, but right now in today's environment, 99% of the time, you're going to need a revocable trust. Okay. We do irrevocable trust, but it's for special situations. So most of the time when people say, I want a trust or whatever, it's going to be a revocable trust. And there's a huge difference between a revocable trust and an irrevocable trust. So let me just tell you the big difference. A revocable trust sounds like what it is, Leann. You can revoke it. You can make changes to it. You can add things to it. You could subtract things to it. You can do whatever you want with this document. Versus an irrevocable trust, once we have it set up, bam, it's pretty much set in stone. There's not much we can do to it. And you have no control. So really, if you think about it, a revocable trust, you have full control and flexibility. An irrevocable trust, you have no control and not much flexibility at all. Those are the key differences in the regards to revocable versus irrevocable.
So, not being an attorney myself, just a layperson, I'm going to guess. So, a revocable is probably more like what people think of as a living trust, where they're doing life. They might be selling a house, buying a house, cars, different things like that. And an irrevocable might be more like a scholarship fund. How far off am I?
Yeah, no, you're not far off at all. Good job, by the way. No, so yeah, a living trust, a revocable trust are the same thing. So,
Good to know.
so that's what I'm saying. About 95% or more of everything that we're talking about with regards to trust, people are thinking about that living trust or revocable trust, and we'll talk about how it works in a minute. But the irrevocable trust, usually we do it now. I do it now more than ever for Medicaid planning, which is a whole separate topic, but we'll get a little bit into it today.
Okay.
But it's more for Medicaid planning purposes these days than anything else. And let me give you an example. So many, many years ago, if we go way back in time when I was a young pup, when I was a young attorney, okay, we had a federal estate tax, and the federal estate tax was $600,000. So that meant that if you had more than $600,000 worth of assets, Uncle Sam would collect money for the difference, anything above that. And it was a pretty hefty tax. So in that situation, and they counted everything, Leann. So your house, your investments, your stocks, your bonds, your mutual funds, your annuities, also life insurance. So imagine if you had $1 million life insurance policy, you're over just with that by 400,000 back then. So what would happen is you would have the life insurance, you'd have your house, you'd have all these investments, and let's say the federal tax was 600,000 and you had $2 million of assets. Well, that $1.4 million difference is going to be taxable. So in those situations back then, we used to do a lot of irrevocable trusts. They're called ILITs, irrevocable life insurance trusts. And the only thing in that irrevocable trust would be a life insurance policy. And because it's irrevocable, it's not counted in your assets when you pass away because you have no control. So because you have no control, it's not counted anymore. And so what you usually would put in there would be the only thing in that ILIT or irrevocable life insurance trust was a life insurance policy to pay the tax. So let's say you owed 400,000 on that example we just gave. You would have a $400,000 death benefit policy in an irrevocable life insurance trust. And when you passed away, the irrevocable trust, the insurance would come due, and then that would pay the tax. And then you kept your $2 million estate whole for the family. That's what used to happen. There's really not much need for that for the majority of people today, because right now, I forget what the tax is. I think it just got jumped. I'm not sure. I believe, I'm guessing, so forgive me, guys out there. It's around $15 million a person. So a married couple, it's about $30 million. So if you have less than $30 million, we don't have that tax problem anymore. So that's why it doesn't, a lot of times we don't do the irrevocable trust anymore.
And my brain had to go there. And if you are over $30 million, then you have attorneys that are helping you anyway.
Exactly. Yeah. So there's lots of times where I have clients that are in, not lots, but there are times when I have clients that are in close to that threshold. And so we have to deal with planning accordingly at that point. But, the majority of everybody out there, we're never going to have to deal with it. So when we talk about trusts, we're talking about revocable trusts. We're talking about the living trust, as you said, Leann.
Yeah.
Did that make sense, or did I bore the crap out of you?
No, that makes total
Okay.
sense. And as you said, things have changed a lot from the olden days. And I was selling trusts actually probably about the same time that you were a new attorney. So I was helping families. I was collecting the information for an attorney
Yeah.
to set up their living trust. And I have one as well.
Yeah. I have one as well with my wife. So there you go.
Which desperately needs updating. And I know it's a revocable living trust because I can still manipulate it and put things in and as I've moved and grown and my children have grown. And you want that.
You said something without even knowing it, by the way. You said, I have a trust and, which needs updating. And that's really important, Leann, because I tell people, again, we've said this before in other podcasts, but estate planning, guys, is dynamic, not static. Okay? Things change. You don't just set it and forget it. And the same is true if you have a revocable trust. You need to look at it because guess what? Every couple of years, I tell everybody once to twice, maybe once or every 2 years, you should be looking at your documents and seeing what's changed. Listen, I'll give you a prime example. I have a daughter, Allie. She's getting married in 3 months. So now, hopefully a year or two from now, there might be a grandchild down the road for us. So now, guess what? I need to look at my estate plan and say, you know what? I would like to add some inheritance to my grandchild down the road. So those are things, that's why it's really important to always think of estate planning as a dynamic situation. You always need to review as life changes. People die, people get married, people get divorced, you get pissed off with somebody, you don't want to give them anything. That happens daily in my practice.
When families in Florida are trying to avoid probate, then which type of trust is typically used and why?
Both trusts, irrevocable trusts and revocable trusts, are supposed to avoid probate. Okay. But the majority of people, we do the living trust / revocable trust to avoid the probate process. That's the main purpose there's two main purposes, in my opinion, as an attorney. Now, There's lots of attorneys out there, guys, so there's going to be a lot of different opinions. But in my opinion, the 2 to 3 main purposes of a revocable trust is number 1, to avoid probate court when you die, and we're going to explain how that works, okay? Number 2, to avoid guardianship court if you become disabled. We're going to explain how that works. And number 3, to make sure the assets go smoothly, however you want it to go when you do pass away. So let's break it down. 1, 2, 3. Here's how it works. The trust, when you think of the trust, and I'm talking about a revocable / living trust, Leann, there's 2 steps. The first step is you need to sign it, you need to witness it, you need to create it. That is called, at that point, that is step 1. I like to describe it, if you're watching the video, I'm holding my hands up like a trash can. I like to say that we built an empty trash can or an empty box. That's the first step. The second step is you need to fill it up with assets. That term is called funding or populating a trust, and that's just a fancy legal term for meaning filling up assets. When you pass away, Leann, anything that's in that box avoids probate and will act like what everybody thinks of as a will and will just go. So that's how a trust avoids probate. But people don't think about this, Leann. What happens if, God forbid, Leann, you get in a car accident and you're unconscious and you're in a coma or something, and you can't handle anything. You're not mentally able to handle your financial affairs. You remember Britney Spears, the singer in California?
Yes.
Do you remember that whole fiasco with her dad handling her assets?
Oh, well, her and so many people, but yes.
So when a couple of years ago in California, she was basically, they determined through the courts that she was not able to handle her financial affairs, that she was incapacitated. So the courts appointed her father as a conservator, as the person in charge of her assets. And then her father went and did all sorts of crazy things with the money, and it was a nightmare. And there was millions of dollars lost because he did things that weren't right. And so it was a huge battle for years. Britney Spears battled her father and the courts to say she's now competent so she can take over her assets. If you have a revocable trust and you become disabled, the trust will also avoid the guardianship court, or the conservatorship in California. So you need to understand there's really 2 purposes for the trust. One is to avoid probate and make sure it goes smoothly to all the beneficiaries when you die. But also, if you, God forbid, become disabled or incapacitated, we want to make sure we avoid the guardianship court as well. And that's the other purpose of that trust.
So say it again and say it slowly so everybody hears it. Which type of trust avoids guardianship?
Both. Which trust are people going to use? 99% of the time, the living trust or the revocable trust. That's the one you're going to be using almost all the time.
So if we go to that, we say so just to be clear on this, we're going to go with the revocable trust since that's the most common. And then you become incapacitated, which means you can't control it. It doesn't at that point go on to the trustees, though, because you're still alive. Am I getting this?
Yeah. It gets confusing. So let's take a step back. And this is Trust 101 that we're talking about here. So when we set up a trust, okay, whether it's revocable or irrevocable, there's 3 legal hats in the trust, okay? And it's called the grantor, the trustee, and the beneficiary. Those are the 3 legal hats. In a revocable trust, the person that sets up the trust, the legal term is called the grantor. If Leann, you came to me and said, Andy, we need a trust, what do we do? I would make you the grantor of the trust. Even though I drafted it, legally it's your document, you are the grantor. In addition, the person that manages the assets that are in the box, that are in the trust, the term is called trustee. You're also going to be the trustee, okay? In addition, while you're alive, you're the beneficiary of everything. Now, when you pass away, you're no longer the beneficiary. because you named other people to get your assets when you passed away. So that's how that works. Now, if you become disabled or incapacitated, you're right. Here's what happens. You're still the grantor, the one that created it. You're currently the trustee and the beneficiary, right?
Yeah.
But now you can't manage it. So we need to name another trustee to slide up and to take over for you for your benefit, though, because you're still the beneficiary. The assets are meant to be used for you, right? So you maybe named your daughter, if you have a daughter. Your daughter would slide up and would manage the trust on your behalf for your benefit in a revocable trust. Did that make sense?
100%. But a
Okay.
conservator would also need to be managing assets for the benefit of the person he's conservatorship for. Am I wrong?
You're correct if the assets are not in a trust.
Ah,
If the assets are in a trust, we avoid the entire conservatorship/guardianship courts. That's the whole purpose. So Britney Spears must not have had her estate plan set up properly.
sure.
She must not have had trust work or anything like that, because then the successor trustee would have just automatically taken over with doctor's notes saying that the person is that Britney was disabled or incapacitated, and then the successor trustee would take over, and there's no guardianship court or conservatorship, and the trustee just handles things, and you avoid all these court hearings and thousands, if not millions of dollars in the Britney Spears case of court fees and expenses.
Well, we just have a couple minutes left here, so I want to jump into one more area and reason to have a trust. And people talk about Medicaid.
Yes.
Irrevocable trusts come up a lot with asset protection. So, what makes them useful in that situation?
So yeah, so remember how I said earlier in the podcast that we rarely do irrevocable trust now. It's that irrevocable life insurance trust. It's kind of gone by the wayside unless you have a lot of money now. What we do use the irrevocable trust for a lot of times is for Medicaid planning. So what happens is, and that we're going to have a whole nother podcast just to talk about that, which is, I don't want to go into too much detail, but what you need to know is that when we move assets into a special type of irrevocable trust for Medicaid purposes, once you move the assets in there, it is no longer counted for Medicaid planning purposes. So it's a way to get you to be qualified for Medicaid benefits for long-term care, assisted living, home health care situations. It's a very complicated process. I don't want to go into too much detail about it. There's a 5-year look back. There's all sorts of things that we have to talk about. That's a whole separate podcast, which, by the way, we're going to be doing. So be on the lookout for that one. But yes, so most of the time now, Leann, when we talk about revocable and irrevocable, the irrevocable trust is most of the time I'm dealing on the Medicaid side of the situation, and everything else is the revocable side where we have control.
Perfect. Thank you so much for all of that and letting me dig in. I love that. So, to our audience, we want to thank you for listening to If You Don't Plan, You're Stupid. Understanding the difference between revocable and irrevocable trust can help you build a plan that actually protects your family and your assets. If you want guidance on which type fits your situation in Florida, visit rosenberglawfirm.net to get started. And remember to like, subscribe, and leave a review if you found this episode helpful. Thank you, Andy. Such a
You're
pleasure.
welcome, Leann. Bye, guys. I hope this was a good podcast for everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.
If you don't